Good evening, family and friends. Once again, we're together going to go over this writ of habeas corpus. This will be part 3. I noticed that not quite as many people watched part 2 as they watched part 3. And that's all. That's up to y'all, man. I'm just putting it out here. Do with it what you will. But like I said in the first video, this stuff is vital. It really is, knowing some of this stuff. There have been a few people get in here and they haven't got a clue. They still got their heads stuck in that old slave mentality. I hope this frees you all. I hope this frees your mind. I'm not going to argue with any of y'all, your opinions or whatever about this. Take it or leave it. There are a few folks that like to get on here and contradict and talk about nonsense and just totally negative. If it's so wrong and you disagree with it so much, why are you so absorbed in watching every one of these? Move on. If you think it's BS, move on. But anyway, I was going to finish up with the subject matter jurisdiction, but there was only a few more pages left in that, and you can go through there and read those. But tonight we'll start on the Constitution is designated to protect the commercial interest of its sovereign and corporate persons, pursuant to Article 1, Section 8. The Constitution of the United States was formed to establish a national government, and the court is the most important part of the government thus formed. One of the essential objectives of the Constitution was to erect a government for commercial purposes, for mutual dealings. See Bank of Augusta versus Earl. As I stated above, the person accused, named in the complaint information indictment, is not and was not the claimant at law. Your human name, beneficiary. And therefore the criminal court was in error. See Uniform Commercial Code, Section 1, 201-27. Person means an individual, corporation, business, trust, estate, trust, partnership, limited liability company, association, joint venture, government, and governmental subdivisions, agencies or instrumentalities, public corporations, or any other legal commercial entity, hereinafter UCC. Also states that the applicability of supplemental principles of law, unless displaced by the particular provisions of the Uniform Commercial Code, the principle of law and equity, including the law merchants, and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating causes supplemented is provisions. See UCC 1-301B and Section 1-105. Because the court deals with an artificial fictitious corporation or corporate entity, see Debtor. See Debtor as defined in the UCC Section 9-103A2, and not sovereign, the natural living being, beneficiary, and failed to serve notice that it was doing so. Remember that notice that they served, they're not serving it on you. the sovereign, they're serving it on your strawman or your trust business entity, known as the all caps name. UCC 1-201, 26 and 27, 1994, and that it would be placed on the record. UCC Section 5-102A14. It has effectively created a fault and a breach of good faith. UCC subsection 1-201, 17 and 20. Therefore, any contract cannot be binding. That they lose the contract when you break this out. When you break all this stuff out on them, their contract isn't binding. The contract that they're trying to scare you into. This is common in child support. You go into child support and it's all commercial. The whole thing is commercial. Even the referee will tell you that they're not a judge. And they always want you to sign some paper at the end of it. Here, sign this paper. You don't get the original. Why? Because that original wet signature is going to generate the money that they're going to get from your trust. Well, we're going to bring you back a copy. You're signing contracts. Those contracts can be revoked using this knowledge. Get away from them. Like I said in some early videos, you're going to produce a child with another woman, whether you care for her or not. That child is still your responsibility. You don't need the government. You don't need the corporate state of Tennessee telling you that you need to pay to take care of this baby. You don't need them to tell you when you can have your child. Most states, it's 50-50 now. I wish that was back in the early 90s when I was going through mine. Didn't work that way. The system was made to screw the non-custodial parent. Therefore, any contract cannot be binding. See UCC 1-201, 3 and 12. No sanction can be imposed upon the natural human living being. Beneficiary, the Christopher -Allen : beneficiary. However, the state of Tennessee, this is in quotation marks and in all caps. However, the state of Tennessee cause does leave this aggravated party any opportunity for remedy, relief, and the rights afforded by Universal Commercial Code subsection 1-106, 1 and 2, and in section 1-201, 32 and 34, and the state and federal constitutions. In this cause, the state of Tennessee, all caps, court completely rely on federal rules of civil and criminal procedures, which are structured for the use of federal, Admiralty, maritime, and statutory jurisdictions. See the Enabling Act. Article 6, Section 8 of the Tennessee Constitution. Whether criminal, civil, or commercial, based on this structure and following these rules and regulations in order for the, all caps, state of Tennessee court to bind a party to action, and in order to obtain and sustain jurisdiction, the court must supply a contract bearing the true name and bona fide signature of this sovereign, requiring specific performance, or in the alternative, a valid complaint submitted to the court, signed by an injured party, victim, and entered on the court of record. The criminal court for the state of Tennessee has failed to comply. You always hear everybody goes, where's the victim? Where's the complaint? It's not. It's always the state going after the cops, one that's prosecuting, or the investigating agent, TBI, or whatever. If a court fails to do so, then the court cannot enforce its demands as stated by the United States Supreme Court. This is what the United States Supreme Court said. Entities cannot compel specific performance upon its corporate statutes or corporate rules unless it, like any other corporation, is the holder in due course of some contract or commercial agreement between it and the one whom demands for performance are made, and is willing to produce said document and place it into evidence before trying to enforce its demands, called statutes. There's an emphasis added by me. That's Clairfield Trust Company versus U.S. 318 U.S. 363, 1943. Empire Health Choice Assurance in Inc. versus MacV, 547 U.S. 677, the year 2006. The Uniform Commercial Code makes clear of its intentions in 1-103A3, which states, to make uniform, this is quotes, to make uniform the law among, let me start this over. To make uniform the law among the various jurisdictions, it is clear that this aggravated claimant at law, sovereign, the natural human living being, upper and lowercase, beneficiary of the CES Trust, is not in any way responsible for any alleged acts requiring specific performance or any other obligation created by the accused. Debtor CES Trust states in pertinent parts as followed. Secured party not obligated on contract of debtor, the existence of a security interest or authority given to the debtor to dispose of or use collateral without more does not subject a secured party to liability in a contract or tort for debtor's acts or omissions. The UCC 9-402. It is a documentary fact that the CES Trust is transmitting utilities and the fiction, artificial entity other than the sovereign, the natural human living being, beneficiary and sovereign, as a sovereign claimant at law with a security interest with the debtor and record owners of the document in this action. There can be no law that can supersede the holder in due course, priority claim, or sovereign. The documents that purport to hold the debtor CES Trust to any particular obligation have been accepted for value by the secured party, sovereign claimant at law, thereby discharging the public debt. And it goes on to he talks about the release. For the record, be it known that there is a presumption with respect of the facts relating to the U.S. Constitution that is designed to protect the commercial interest of the sovereign and corporate persons pursuant to Article 1, Section 8. The next part is The district attorney's office committed fraud and fraudulent concealment. The claimant of law attests that the district attorney's office perpetrated a fraud by using trickery or artifact to not only bring the claimant at law into the Admiralty, maritime, and statutory jurisdiction disguised as a criminal court, but also to secure multiple penal bonds in exchange for a conviction of the charged offense or offenses, or an agreement to some of the charged offenses. Fraud is defined, and then it defines fraud: any trickery or artifice employed by one person to induce another to fall into error or to detain him in it, so that he make an agreement contrary to his interest. The fraud may consist of either first in the misrepresentation or secondly in a concealment of material facts. Okay? And then there's definitions in here. Fraud, and in Black's Law, in Bouvier. Fraud, actual fraud, bank fraud, fraudulent concealment, passive concealment, and concealment rule. Fraudulent concealment in a couple of different dictionaries, legal dictionaries. Here the trespasser, state of Tennessee, committed fraud when it hid their true intent, which was to first charge the artificial fiction entity, CES Trust, then obtain the Admiralty Maritime statutory jurisdiction, and finally to obtain access to the CES Trust in order to secure a conviction and hold the claimant in law and custody for a criminal conviction on nothing more than a commercial crime or crimes as collateral for the commercial value of the penal bonds. I've been saying all along, you're held as collateral for the penal bonds. Such silence by the district attorney's office as to their commercial activity constitutes a fraudulent violation of the trust. The district attorney's office knowingly, deliberately, and intentionally perverted the truth for the purpose of inducing the claimant at law into error by submitting him to Admiralty, maritime, and statutory jurisdiction by falsely misrepresenting and concealing material facts of the true nature and jurisdiction of the court, which is for the purpose of deceit, deception, artifice, or trickery in order to use the commercial energy from the artificial fictional entity, CES Trust, to secure and conviction as collateral for the commercial value of the penal bonds. See above definitions of fraud. And subject matter jurisdiction, mandatory requirements of an enacting clause. This is probably the part of the document that I really this cuts the head right off of the snake. It's the enacting clause, and it's I think I may have even read the definition already. So the enacting clause is whenever a law is made in the legislation, it'll say what the law is: forgery, and then it'll give the code that it intends to place it in. And then before the description, there's supposed to be the enactment clause, and that's where the states are basically put the state and the federal government, the federal legislative offices do the same thing. There's a particular sentence that they use. Every state's a little different. Some states copied others, but it always has this enacting clause in it. If it doesn't have it, it's not a law. And most of y'all can look and see that it doesn't have it. When you look up the codes, they don't have it. It's a mandatory requirement to have these. Every case can be completely thrown out because they don't. They may have used them in the 1800s, but you don't hardly ever see them used anymore. They just make their statutes however they want and call them laws. You're not following. I had one guy tell me, you got to follow the laws of the land. Yeah, you do. You do have to follow the laws of the land. But you don't have to follow the rules, codes, regulations, and statutes. It's not the law of the land. So, the mandatory requirements of an enactment clause. The question has often been raised as to whether constitutional provisions that call for a particular form and style of law or procedure for their enactment are to be regarded as directory or mandatory. Two different words there. The question is critical since its use will have an effect on the validity of a statute or law. As provisions are directory, then they are to be treated as legal advice, which those in government can decide whether or not to follow. But if mandatory, such provisions must be strictly followed, or the resulting act or law is unconstitutional and invalid. While few courts at an earlier period held that such provisions were merely directory, the great weight of authority had deemed them to be mandatory. In speaking on the mandatory character of the enacting clause provisions, one legal textbook states, the view that is, this is it from this textbook, legal textbook, the view that is provision is merely directory seems to conflict with the fundamental principle of constitutional construction, that whatever is prohibited by the Constitution, if in fact done, is ineffectual. And the vast preponderance of authority holds such provisions to be mandatory, and that a failure to comply with them renders a statute void. See Ruling Case Law, Volume 12, Statutes, Section 84, page 836. When something is directory, as usage is only an advisable guide and can be ignored. But the requirement of an enacting clause is based upon an ancient usage in legislative acts. A declaration of the enacting authority in laws is a usage and custom of great antiquity, and a compulsory observance of it is found in sound reason. See Kane versus Robinson, 131, 2nd, 6:16 and 5:18, Nevada, 1942. The following are examples of other states like Tennessee that declares that the style of the laws shall recite, and this is Tennessee's, be it enacted by the General Assembly of the state of Tennessee, is not merely directory, but must be complied with. See Article 2, Section 20 of the Tennessee Constitution. The Supreme Court of Illinois, under consideration of observance with no enacting clause, the court expounded upon an ordinance with no enacting clause, invalidated the law stated. And this is what the Illinois Supreme Court said. And it has to do with an ordinance, like, say, a village ordinance. Upon looking into the Constitution, it will be observed that the style of the laws of this state shall be enacted by the people of the state of Illinois, represented in the General Assembly. That's Article 4, Section 11. The foregoing sections of Article 3, 4, and 5 of the Constitution are the only ones in that instrument prescribing the mode in which the will of the people, acting through legislative and executive departments of the government, can become law. These provisions, given in the form and mode by which valid and binding laws are enacted, are, in the highest sense, mandatory and cannot be doubted. Then it follows that this resolution cannot be held to be law. It is not the will of the people, constitutionally expressed in the only mode and manner by which the will can require the force and validity under the Constitution of law, for this legislative act is without a title, has no enacting clause, and is sufficient to deprive this expression of the legislative will of the force and effect of law, and the same did not become, therefore it is not legally binding and obligatory upon the respondents. They're saying right there that this isn't. It's kind of like these communities with their housing authorities, where they get together. You know, if you're going to be here, you can't put signs in your yard. You know, those are the same thing. They're like ordinances. In Orland Park, Illinois, my parents moved there in the late 80s. It's a southwestern suburb of Chicago. And I asked my dad, I said, why do all the houses here, why are they all brick? And the whole first floor, it's an ordinance that the first floor, the whole first floor of the house has to be brick. So most people had first and second floors that were brick. And I asked my dad, I said, why do they do that? He said, to keep the undesirables out. So what do you mean? Well, to build a house of brick costs a lot of money. That means if you don't have a lot of money, you're not living in Orland Park. And it's really close to some really bad suburbs like Blue Island, and, you know, I mean, they're just a few miles away. That's what they did, and it's totally, go in there and build a house out of wood. Don't put any bricks on it, because their ordinances aren't laws. The Supreme Court of Arkansas, it talks about it and its enactment clause. So, but I'm not going to get into all that because there's a bunch of them here, the different states and laws, and every one of these are saying if you don't have it, it's void. If you don't have it, it's void. It has no force and effect. Yeah, it's all the, and then the absence of an enacting clause. While the United States Constitution and a few states' constitutions do not specifically prescribe that all laws all laws use an enacting clause style, it is used nonetheless its use is nonetheless required by our written Constitution. It means even if your state doesn't have it, the Constitution does. The use of an enacting clause in the use of an enacting clause and even a title exists by fundamental law. They are common law concepts. Like many old and well-established concepts of law and procedures, the framers of the United States Constitution did not feel it necessary to write into the requirements of the enacting clause or titles on all laws. There are so many of these fundamental concepts that it would be impractical to list all in a constitution, but that does not mean they don't exist. Just like the rights enumerated in the Bill of Rights were not originally written into the Constitution because they were recognized to be so fundamental, it would be superfluous to list them. One of the leading, I'll just read one of these. Or wait a minute. The use of an enacting clause is thousands of years old, and every state in the United States has followed this custom from the beginning. Thus, from something to be regarded as true and valid, it is logical that one would expect to see an enacting clause on its face, on the very first page of it. One of the leading cases on this issue was from the Supreme Court for the Territory of Washington. This was before Washington became a state. The validity of an act of the territory legislation that would move the seat of the government was in question. The act had no enacting clause, and the territory had no constitution of its own requiring one. It was generally governed by the United States Constitution. The court held the law invalid, stated that strip this act of its outside appendages, leave it solitary and alone. It is possible for any human being to tell by what authority the seat of government of Washington Territory was to be removed from Olympus to Vancouver. The starring fact that the constitutions of so many states, made and perfected by the wisdom of their greatest legal lights, contained a statement from an enacting clause, in which the power of the enacting authority is incorporated, is to our minds a strong and powerful argument of its necessity. It is fortified and strengthened by the further act that Congress and the other states, to say nothing of English Parliament, have by almost unbroken customs and usage, prefacing all their laws with some set form of words in which it contains an enacting authority, guided by the authority of such eminent jurists as Blackstone, Kent, Cushing, and the precedents of national and state legislation. The court arrives with the satisfaction and consciousness of right in declaring that where an act like the one now under consideration is wanting in the essential formality and solemnities which have been mentioned, it is inoperative and void, and of no binding force or effort. This is in re seat of government, 1 Washington Territory, 1/15/123, 1851. The court here judged that the validity of the law based upon fundamental law rather than on specific constitutional provisions. This case has been cited quite frequently by various legal texts and courts that is always in a favorable or approved manner. The enactment clause, folks. And the next part is the enacting clause in publications of statutes and books. I'm not going to get into that. You can go back and read that. But it's an argument, too. When you guys put these together and you got your Tennessee Code annotated or your Illinois Code annotated or Kentucky Code annotated, that they're in there. And they have to be in there. So they're getting you with, oh, you broke the law. You robbed a bank. You broke the law. No, more than likely it's a statute. And they're void. They're all void. So I'll leave that to y'all to check that out on your own. Except, thus, laws as they are taken or cited from statute books have no enacting clause, cannot be used to charge someone with public offenses because they are not valid laws. That's from, let's see, Vincent Court, Article 5, Section 19 in Arkansas. So, in the publications, it talks about how they have to be in the publications. And they're from a bunch of different states. And every little piece of this, when you submit these, every little piece of these things have to be addressed. Procedural, when I do the next one, it'll be procedural, judicial, and arguments and criminal jurisdictions. That'll be the next part that I do this on. But we're 37 minutes into this one already, so I'm going to break it up. Now, look, y'all, like I said earlier, watch these, man. Get your copies. I talked with the guys. They're supposed to be getting them. I think You Have the Right .com was having it converted from the PDF and into a Word document, so you guys can strike stuff out of here that doesn't pertain to your particular situation. But the enactment clause is there. You could probably do a habeas corpus and say, where's the enactment clause? And have it thrown out strictly on that case. And I think, I'm pretty sure over there in Legal IBUS, it's there too. If you're in the Telegram, I know it's in the Telegram. It's in the files in the Telegram. But get those, and print them out, or download them onto your phone. You can listen to this and see this stuff for yourself, and then look up the case law. I've only had one person so far come back and say, I looked this up in the case, and there wasn't nothing. I looked this case over thoroughly. I'm not saying that I'm saying you can find it. Every one of these I have, or one of my members that helped me build this said, hey, Chris, look at this right over here on LexisNexis. They're finding it. But anyway, I will get back with another one here shortly, part 4 shortly. Until then, y'all be blessed.